Madam, allow me to thank members who have risen to support this bill. The endorsement of our proposal to amend the Administration of Muslim Law Act, or AMLA, is indeed crucial. Let me now address some of the points and queries raised. Madam, I happen to see the strong support for marriage preparation programs for minor couples. Strong families are the foundation of a resilient nation, but many of us would know building a strong family requires constant effort, good communication, and mutual understanding. These are but some of the important practices that our marriage preparation programs seek to promote and encourage among couples. So during the public consultations, there were also calls from the community for the marriage prep programs to be made mandatory for other couples, a point raised also by Mr. Fazal Mana. Marriage education programs tailored for different groups are already available, but we're making it mandatory for minor couples for now, as they represent the group that most require support. This is similar to the approach adopted for minor marriages under the Women's Charter. And we have several approved private partners on board offering the Cinta Abadi Marriage Preparation Program for Muslim first marriages, and this makes the program accessible and convenient for all couples to attend. In fact, when we developed the Cinta Abadi program, this was done in consultation with MUIS, Sharia Court, Registrar of Muslim Marriages, and other committee partners, and they are based on the values of the religion and touches on the pillars of marriage in Islam. So for remarriages, as raised by Professor Fatima Latif, there is a dedicated marriage preparation and enrichment program for the couple and programs for their children to help them adjust. For couples who need more support, counseling and even referral to relevant social assistance schemes and services are provided. Ultimately, it's about helping couples prepare for marriage and educating those who may not be aware of the importance and the availability of such support. As I mentioned in my opening remarks, Madam, the government will continue to study the landscape to assess if more needs to be done to support our couples. So we will start with minor couples, but we will study further as to whether we want to extend it to other couples. Madam, I also like to address the point raised by Mr. Azmun concerning the need to seek consent from the Qadi or the Naib Qadi if a couple wants the wali to solemnize their marriage. I would like to assure him that this does not take away or affect the wali's right to solemnize the marriage. Rather, Madam, it seeks to ensure that the valid wali has been appointed to solemnize the marriage, and once this is clear, the wali can proceed to solemnize the marriage. Madam, there's also strong support for the proposals to better support divorcing couples. To answer Mr. Zainal Sapari's query, the family support programs available for divorcing couples are aimed at ensuring the best interests of children of divorcing parties, and I will highlight three key areas. First, for couples with children below 21 years old living in a HDB flat, the Sharia Court will refer these cases to HDB for the couple to make informed and sustainable decisions on housing post-divorce. Second, the Sharia Court refers parents who have at least one child, aged between 6 to 15 years old, to PPIS As-Salam Family Support Center to participate in PPIS Children in Between program when necessary. The As-Salam Support Center is one of the 4 divorce support specialist agencies supported by MSF, and this program equips parents with co-parenting skills to help reduce parental conflicts and thus minimize the impact of divorce on children. The program also seeks to help the affected children build coping skills to deal with their parents' divorce. Third, divorcing Muslim couples with children up to 21 years old are also required to attend a free 2-hour post-divorce consultation session before the collection of their divorce certificates. This one-time consultation session provided at the Sharia Court is known as Parenting Pact and is conducted by PPIS. The session, Madam, provides further resources and guidance on cooperative co-parenting skills and self-care strategies. It also provides information about the community support resources available post-divorce. So it is hoped that these programs give the strongest support possible to couples and their children in these difficult times. They also complement the parenting plans that couples with children up to 21 years may be required to submit, which essentially are post-divorce co-parenting and care arrangement plans. Madam, there were concerns as to whether such provisions for family support programs or counseling would unnecessarily prolong divorce proceedings. Let me emphasize that counseling goes beyond reconciliation and saving marriages. Counseling, in fact, provides the safe space to discuss the implications of divorce and enable parties to receive proper guidance on self-care and post-divorce arrangements for the children of the marriage. As regards the timelines post-counseling, if the parties are amicable and come to an agreement on the divorce and ancillary matters, their case can be completed within 3 to 6 months. However, there are typically 30% of cases that are either acrimonious in nature or more complex with multifaceted issues. For such cases, it is only to be expected that divorce proceedings will take a longer time. Madam, Mr. Saktiandi was concerned about parties in a divorce being non-cooperative. If one party deliberately tries to stop proceedings, the court has the option to order a stay in the proceedings until the defaulting party attends the prescribed activity or even order costs to be paid to the other party. The conduct of parties often gives the courts insight into a parent's relationship with their child, and if there is a clear disinterest or lack of cooperation, such conduct could be relevant for the court in its subsequent deliberations on custody and access orders. So I'd like to assure members that there is a triage system in place to determine the level of urgency that cases are accorded. Irreconcilable divorce cases with the risk of domestic violence, for instance, will be expedited for the safety of the victim. Madam, I'll now move on to the jurisdiction on divorce. Both Madam Rahayu, Mr. Saktiandi, and even Mr. Louis Ng spoke of a Singaporean lady who obtained a divorce in Johor, but faced difficulties in settling her divorce ancillary matters in Singapore. I believe they're referring to the case of TMO versus TMP 2016, which was brought to the Court of Appeal. Madam, the court eventually allowed the appeal for the wife to seek financial relief at the High Court on the basis that Chapter 4A of the Part X of Women's Charter can apply to Muslims where necessary. More importantly, the Court of Appeal confirmed that there is no lacuna in the law. The High Court retains residual jurisdiction over matters which do not fall within the jurisdiction of the Sharia Court. So therefore, parties to a foreign Muslim divorce are not stranded, as they can proceed to the civil courts to claim financial relief, including an order for the division of matrimonial assets. As was done in this case, the Sharia Court will continue to make orders related to both nafkah idah, which is the maintenance during the period which the divorced woman is forbidden by Muslim law to remarry, and muta'ah, the consolatory gift upon divorce. We will therefore continue to keep to current practices and laws. In some ways, we ensure parity in approach, in that if Singaporean parties had their marriage dissolved outside Singapore, there is a common forum in Singapore which is empowered to hear and determine parties' claims for other ancillary relief. Such cases may often be more complex as well. So we will continue to monitor the situation and engage relevant agencies and stakeholders closely, including the Ministry of Law, the Muslim Law Practice Committee of the Law Society of Singapore, or the MLPC, with a view to better rationalize our processes and systems in future if necessary. Madam, let me now address Professor Fatima's and Mr. Saktiandi's comments on the management of our waqafs. First and foremost, there was no specific case that prompted these amendments. But allow me to iterate some key points. By virtue of AMLA, it has always been MUIS's responsibility to administer all waqafs. Trustee management is critical to the management of waqaf because the accountability that comes with trusteeship helps ensure that the waqaf is maintained and developed well. Disputes related to trusteeship can be complicated, messy, and potentially long drawn. In the medium to long term, the management of the waqaf can be adversely affected. So it is therefore is MUIS's priority in the interest of all waqaf beneficiaries to ensure our waqafs are run well so that they can generate the maximum returns and are sustainable in the long run. The effort to introduce a waqaf dispute resolution committee was an innovative but necessary approach by MUIS to ensure that there are neutral individuals with the necessary expertise to help mediate disputes. So to answer Mr. Faisal Manaf, we do have a scheme beyond the civil courts to deal with waqaf resolution within the Muslim community through AMLA, through MUIS, through the Waqaf Dispute Resolution Committee. So we do not want the waqaf's resources to be drained by unnecessary legal fees. This committee is thus an expedient and prudent option, especially made available for our trustees and mutawalis who we value greatly for their contributions to the community. Madam MUIS will continue to engage the trustees and mutawalis to ensure that they are all aware of this platform as well as their respective roles and responsibilities. Disputing parties who do not agree with the manner in which the MUIS Council reached its eventual decision can resort to judicial review by the courts in appropriate circumstances. But we will advise against this and would rather all parties come together for amicable resolution. So let me stress again, Madam, that AMLA have long provided for MUIS to administer all waqafs. These amendments are intended to add greater transparency and clarity to MUIS powers, such as in the grounds for removal for the benefit of trustees and mutawalis. But I wish to stress that these amendments on waqaf management should not be misinterpreted as an effort to give MUIS unfettered power. They also help provide more self-sufficient avenues for the Waqafs through contributions to a sinking fund for the maintenance and upkeep of the Waqaf. We must laud the noble efforts and farsightedness of our community's early philanthropists in establishing the Waqafs. We must also commend the good work of all the trustees and mutawalis who have looked after the Waqafs well ever since. And so we will continue to respect the traditions and objectives of the very trust deeds that gave life to these Waqafs. They are as much a part of our history as the important community institutions of today. Madam, allow me now to address some of the comments on the Mosque Building and Madrasa Fund, or MBMF. The regular contributions from the community to the MBMF over the years made possible the building of new mosques and the upgrading of existing ones. Ma'ruf Mosque and Yusuf Ishaq Mosque are our newest mosques built with MBMF resources, with another in Tampines North set to be our 27th MBMF mosque. Since 2009, MUIS have leveraged on the MBMF to add over 23,200 prayer spaces, build more religious class facilities, and introduce more elderly-friendly and disabled-friendly features in our mosques. In the past year alone, we have seen 6 mosques upgraded, such as the Al-Mutaki Mosque in Al-Mukyo, Al-Hir Mosque in Chua Chu Kang, and just recently, the Haji Muhammad Saleh Mosque at Palmer Road, down in Shenton Way. So when we brought this proposal to the public consultation, the reception was positive, but there were similar concerns to what was aired today. There was recognition that good development of our madrasa students is critical to fulfilling our hardware, our institutions with our strong software. But there were also concern as to whether disuse of the MBMF may compromise allocations in other areas such as our mosques. I would like to give my assurance that these users will not compromise the existing building and maintenance plans we have for our mosques. MUIS will continue to ensure that the MBMF is used judiciously, and to this end will only approve necessary or useful works for our mosques and full-time madrasas. Madam, let me address 2 more points before I conclude my speech. Professor Fatima, Madam Rahayu, and Mr. Zainal raised 2 areas which were not included in this round of amendments to the Act. On Professor Fatima's and Madam Rahayu's query on having more amendments related to inheritance and nuzriah, allow me to state at the outset that my team and I would recognize the need for a comprehensive review on these matters, and I've said the same to the committee leaders when I met them in March this year. More time is required to assess the changing landscape and study the implications of any such amendments to AMLA. So MUIS and MCCY are happy to work with our stakeholders, such as the Muslim Law Practice Committee of the Law Society of Singapore, MLPC, and the Muslim Financial Planning Association, MFPA, on this review to better serve the interests of the community. In the meantime, members of the Muslim community are currently already able to make gifts during a lifetime or make nominations to benefit the parties that Professor Fatima and Madam Rahayu mentioned, such as non-Muslim parents or adopted children, through their CPF and insurance policies, or separately through a will. Madam Professor Fatima touched on the recent challenges in the Muslim world, which I take to mean on exclusivism and extremism. Madam, I will highlight that MCCY and MUIS recently introduced subsidiary legislation through the Administration of Muslim Law Act Rules 2016 to better support the Asatiza fraternity as well as our Islamic education centers and providers. The rules came into force on 1st January this year. Central to the rules is a code of ethics, which all Asatiza and Islamic education centers and providers are required to abide by. The values within the code are easily relatable to the wider community, such as recognizing diverse opinions and schools of thought in Islam, not denigrating any racial or religious group, and not advocating any idea that is likely to encourage extremism or violence. To answer Professor Fatima's query, there are indeed processes in place to assess if an Asatiza has breached the Code of Ethics. The Asatiza Recognition Board will assess the matter and will subsequently put up a recommendation to MUIS on the next course of action. Another aspect of the rules is that all individuals who wish to teach or preach Islam must be recognized under the Asatiza Recognition Scheme, or ARS. Our Asatiza bear the heavy responsibility of providing the Singapore Muslim community with sound religious guidance amidst an increasingly diverse socio-religious landscape. They are also our leaders in preventing problematic ideologies and practices from taking root. The ARS thus seeks to raise the professionalism and the quality of our Asatizas and ensure that they continue to be a key source of confidence for the community, one with strong professional qualifications and training to provide guidance on the practice of Islam in a modern, multi-religious and multiracial society. Madam, the battle against radical ideologies cannot be won by legislation alone. MUIS, together with committee partners, have been working closely and putting in much effort over the years to build the resilience of the Muslim community against threats and undesirable influences. This ranged from offering more customized religious education programs and classes to having outreach events and dialogues with parents and youth on complex, contemporary matters and providing counseling in safe spaces for those who require assistance or advice. Madam, I would like to once again thank members for the support of the bill. They remind me of the equally warm reception we received during the public consultations, where many of our stakeholders and committee leaders saw this review as a step in the right direction. It was heartening that from the very start, people saw this as an opportunity to work with the government to strengthen our community. Many indeed came with valuable ideas and suggestions. Some we have incorporated in this round of amendments, while some others we will continue to study with our partners to find the best way forward. So Rayu, wait. What remains important is that we must continue working together, for we will always be stronger when we are united, and it's this spirit and confidence that will see us through no matter what the challenges are to an even brighter future.